Hi, I'm attorney John Mangan. Our firm specializes in the area of wills, trusts, and estates. And as part of our practice, we have an opportunity to represent a lot of people who are the appointed executor or personal representative for a loved one's estate after they pass away. So this video today is really part of a multi-step sequence that we're filming all about the probate process. And today we are focused specifically on what we call marshaling the assets of the estate. So let's start with that phrase and really explain what that means, marshaling the assets. So really it means collecting and identifying all of the assets that belong to our decedent and that are now owned by the estate. Sometimes this is fairly straightforward. So we have a variety of different types of assets we might come across. If we are working with bank and investment accounts, then hopefully we've come across statements that may come through the mail, or if it's online only, hopefully we have access to those accounts. And if not, we hope at least that we know what institutions may house these accounts that the decedent owned. So what we'll do there is contact the financial institution and show them evidence that the personal representative has in fact been appointed by the court to act as such, and then request that the financial institution update the ownership on the account so that it's no longer listed under the Social Security number for the decedent, but now it should be under the tax identification number for the estate that our office typically helps the personal representative to obtain after they have been appointed. If we're dealing with real property, so real estate, we think about improved real property in particular, things like single-family residences, condominiums, townhomes, or even commercial property that might have tenants. We need to make sure that access to the property is secure. So who has a key? Is it only people that should have a key? If we are unsure about this, or maybe even just to make sure we are dotting all of our I's and crossing our T's, it's a good idea to change the locks to the property. If we have a tenant in the property, are they there lawfully? Are they under a lease? Or in some cases, do we need to consider some sort of eviction proceedings? If we're talking about personal property, did our decedent keep a list of personal property that they owned? It can be extremely helpful if they did, but I know that's not always the case. So did they own automobiles, collectibles, works of art, firearms, jewelry, gold, silver, and these days, even cryptocurrency? Part of your job as personal representative is to collect and identify these sorts of assets. A couple of ways that you can help get to the bottom of this is make sure after you've been appointed as the personal representative that you are diligently reviewing anything that is mailed to the decedent. Also, go through the personal property that was in their residence, whether they rented or they owned at the time of their death. You may find some clues in there. Now, once all of those assets have been collected and identified, you will need to consider whether they should be liquidated. And liquidation for some assets can take longer than for others. For example, if we're talking about real property, we may need to get a judicial order before the property can be sold. If we're talking about bank and financial accounts, then we're going to want to look at establishing a brand new account under the tax identification number of the estate. And ideally then, if we're going to liquidate, we liquidate all of those other accounts and we distribute the proceeds down into a single estate account. That's going to make things a whole lot easier when you produce the required accounting to all of the estate's beneficiaries at the end of this process, as opposed to if you've got lots of different accounts and you're keeping those active and running throughout this process. Remember that this probate process in whole will take many, many months. And in a lot of cases, it will take more than a full year. Okay, so now that you have collected all of the assets of the estate and hopefully you've moved them into a single estate account, which, by the way, one of the other reasons for doing this is that if you don't do so and if you have investment accounts, those assets are subject to market risk. We all know that markets go up and they go down. And knowing that this process is going to take at least many months, if the market takes a downturn and you're the personal representative, you do not want to be the person that the heirs or the beneficiaries are going to come pointing the finger at if the estate has lost value in those accounts. So that's another very good reason to, in many cases, liquidate estate assets and reduce them to cash. Now, once we have our cash collected in ideally a single estate account, that cash can be used to pay estate expenses, taxes, any valid bills of the decedent, if there are valid creditor claims that we have to pay off. And then ultimately, once all of those things have been addressed, the remaining funds will be split out to the rightful beneficiaries or heirs. So I know that's a lot of information that I just put out there. Remember that this is really just one part of the probate process. So there is a lot to it. And anybody who is acting in the role of personal representative would definitely benefit from the advice of an attorney throughout this process. If you have any questions on anything that I've said or questions specific to a situation that you are in right now, please feel free to reach out to us. You can either pick up the phone and call us or use the contact form on our website. We look forward to hearing from you.